Hi, my name's Christopher Burgon. I own and run Christopher Burgon Solicitors. We're a specialist litigation and commercial law firm based in London. This video deals with the second stage in the process I think it's necessary for business partners, fellow director shareholders who have decided they don't want to work together to separate without going to court. The first video was about getting agreement that from that point on the business will be properly run. And this second video is about taking control of the business if we have to. So, as I've previously said, stage one is speak to your fellow director shareholders and agree that whatever's happened in the past, from now on, everyone's going to work for the success of the company, that whilst you're going through the separation process, you're all going to do your best for the company to make sure it's a continuing success. Now, if that doesn't happen, then you have a decision to make. And the decision is to whether or not you want to take control of the company. And let's speak practically about what taking control of the company means. It means control of the bank accounts, control of the IT systems, control of any confidential information or intellectual property. Now, you have to be careful. You have to be very careful. For instance, if you contact the bank and say, people are taking money out of the bank accounts when they shouldn't, I want to say that there's a dispute between us, what the bank will probably do is freeze the accounts, and that could be very difficult. Let's talk about taking control of the company. You have to be really, really careful. For example, if the bank accounts enable both you and another director to take money out of it, you may think, well, look, he or she, they're just taking money out of it as they wish. If I want to preserve the cash assets of the business, what I'm going to have to do is take that money out of the company bank account, put it somewhere else where they can't get hold of it. Technically, that could be said to be you acting in breach of your director's duties because you're taking money out of the company and effectively giving it to yourself. That's not why you're doing it. Of course, you're doing it to protect the assets, but you have to be absolutely clear that that's why you're doing, and you have to write notes, keep a strong paper trail, and you actually have to preserve that money. Once you've taken it out of the company bank account, you can't then use it as your personal fund because that will reflect very, very badly on you. Getting control of the bank accounts, getting control of the IT, the confidential information, that's easier said than done. What you really should be doing, possibly before you even say to the other side that you want to separate, is make sure that you are either administrators of the IT systems, preferably the sole administrator, but at least a joint administrator. And then if your business partner, your fellow director continues to misbehave, you would have the ability to exclude them from the company IT system, exclude them from the confidential information. In so many cases I see that people ring me up and they say, look, I've been locked out of all the company IT, I've got no access to the information, I've been excluded from the business. If you possibly can, you need to avoid that happening. Now let's go back to what we're saying. We're saying that we want to resolve this dispute without going to court. So hopefully you don't find yourself in the position where you do have to take control of the company. But if you do, it's better to be the one that moves first so that you can set the agenda and you can preserve the company assets. If you're not in that position, then unfortunately it may be that you do have to go back to court or you do have to issue court proceedings in order to secure your position in the company. If you and your business partner can agree to continue running the business and no one is deliberately abusing the business assets or taking things from the business, they're not competing with the business, then that's great. You can carry on with the process of separating without going to court. What we'll look at next is stage 3 of the process, which is looking at an initial valuation. Hopefully you don't find yourself in that situation. You and your business partner continue to work for the success of the company. Neither of you is abusing the company's finances or its assets, and you can carry on with the process of separating without going to court. The next stage in that process, which we'll deal with in the next video, is taking a look at the value of the company. If you find yourself in this situation and you'd like to speak to a solicitor, we'd love to hear from you. Go to the website, press the book a meeting button, that takes you straight through to my calendar. That gives us 30 minutes to speak. Alternatively, you can give us a call or drop us an email. We'd love to hear from you.